this time.
Madam Chair,
Yes.
I would like to make a motion that we reject the amendments and we reject the contract with Blackwater.
I need to refer to a parliamentarian.
So the parliamentary could consider. There was a motion at the last board meeting already to direct staff to revise the agreement and to bring it back, and that's just this item. And before we get into the actual discussion by the board, I would like to have the staff's report on the revisions that were requested, what revisions were made, and
We can discuss
why.
that. First of all,
I'm sorry.
I'm sorry. Point of order here, please. May I ask the parliamentarian?
Just to be clear, I'm not asking for any action. I'm just asking for additional information
But that would come in our
before
discussion.
the board action.
I was going to make the motion to approve the memorandum of understanding, and then we go from there, right? I'm sorry, we're not in this discussion.
What is posted on the agenda is the motion to approve the amended memorandum of understanding that has been introduced by Dr. Roach. On the floor currently is the motion to approve the amended memorandum of understanding.
And we are voting on the six amendments that were proposed at our last board meeting that we will be voting.
So point of clarification, I cannot make a motion to reject the
Not yet.
proposal?
Why not? Why not? Why not?
You're not, be quiet. Yes, parliamentarian, would you please answer?
The question is, can you make a motion to
Reject.
reject
Yes.
the motion?
Which is the motion I made before.
Defeating the motion is rejecting it. So to make a motion, which is already on the floor, would be inappropriate.
I'm sorry, for clarification, was this motion carried over from the last meeting?
No.
Or just, I'm sorry, wait, because you said that there was a motion already on the floor. And I may have blanked out, but I thought the first,
This is the motion.
well, no, just a point of clarification. I didn't hear anybody, the only motion that I heard presented to the board was trustee Violet's motion to reject, trustee Violet's motion. And her motion was not the one that you described. So who made the motion that you just presented to me on the table?
I believe the chair indicated that the next item of business was item 16A, which is in the posted agenda.
Yes?
That is making the motion to amend.
I'm sorry, there's no motion. That's what I said, who made the motion to approve that?
The chair moved the motion 16A. It's an action item on the posted agenda. And you approved to modify the agenda to hear 16A following oral communication.
And Mrs. Baidomi interrupted before I could make the motion. So therefore,
I'll defer to you.
okay. So the motion is to approve the amended memorandum of understanding, the MOU rather, for the period of January 31, 2009 through December 31, 2013, inclusive at no cost to the district. Now, and then I open it up. And I need a second. Is there a second on the motion? Okay, a second. Now we open it up for discussion.
Just before we get into the merits of it, I just want to give the President the opportunity to inform the public of the amendments, because not everybody has actually seen them, and to explain the rationale for the revisions that were presented.
Thank you, Madam President. In the last board meeting, we were directed to address 6 concerns of the amendments which was the amendments which were proposed. So I would just go, the first amendment was amend termination clause to provide a 4-month written notice of termination by either party. The second amendment, which was asked by the board or directed by the board, was amend the confidentiality clause to limit its application solely to proprietary information relating to XE Services LLC business activities such as methods, processes, clients, etc. Third, eliminate binding arbitration clause. Fourth, make California law the applicable law. Fifth, eliminate the clause that give XE Services LLC the contractual right to use SWC facilities. Sixth, eliminate clause for reimbursement for XE Services LEC. During the negotiation process, XE Services LLC agreed to district recommended revision. The contract has been reviewed by the district legal counsel, Miller, Brown, and Dennis. The MOU supports the use of the XE Services LLC facility, U.S. Training Center, Southwest Inc., located at 7685 Saint-Pierre Riviera Road, San Diego, California, for the purpose of firearm training as part of the requirement for the Southwestern College Police Academy program.
Additional information I received this afternoon, matrix identifying the cost of use of and or availability of the use of other ranges within a reasonable, I think for the San Diego County, I couldn't tell entirely. And could the president describe what that is and what options, if any, are available to our students that are within reasonable distance from Southwestern College?
I might add that that's available for the public. In fact, there's a few copies of the same matrix.
Well, that's what it may not be available to everybody. That's why I'm asking that the president go through it.
Madam President, Mr. Edward, we looked at various ranges which we feel are in existence in the San Diego County. We looked at San Diego Regional Training Center firearm range, and is not open to use by the SWC or other private public entities. Miramar Sheriff Range, and we explained also the distance and so on, but range will close for lead cleanup and renovation in May, June 2009. Future availability and cost is uncertain at this time, therefore range is unable to meet the requirements of the program. San Diego Police Department firearm range, the range is only available for the agency during the week and for special events on weekends, not ongoing activities. Therefore, range is unable to meet the requirements of the program. And Madam President, these conclusions, therefore the range is unable to meet the requirements of the program, are drawn by our director of the academy program. So it is a knowledgeable person who is coming to that conclusion. Discount gun indoor range not open to use by SWC. Project 2000 shooting range facility 2082 Willow Glen Drive. Consistent availability of the range is not guaranteed. Therefore, range is unable to meet the requirements of the program. Discount gun indoor range not open to use by SWC. American Shooting Center. Consistent availability of the range is not guaranteed, therefore range is unable to meet the requirements of the program. SD Gun and Rod Club, consistent availability of the range is not guaranteed, therefore range is unable to meet the requirement of the program. U.S. Training Center, Southwest Inc., that's what we are talking about, no cost to the district. The district has an existing MOU for use of the range at the U.S. Training Center, Southwest. This agency range accommodated the police academy scheduling needs and meet the requirements of the program.
Thank you. Yes, Ms. Saucedo.
If it's all right, with Dr. Chopra's authorization, I would like to go ahead and hear from our staff who are actually in charge of the program. Do we have anyone here that?
Do we have
I would like to call upon the dean from Otimesa here, and I'm sure, oh, here is. Would you please?
Good evening. Well, what I would like to do, and thank you for this opportunity, is perhaps start by providing a little bit of background information on the Police Academy that might be helpful. First of all, the Southwestern College Police Academy has been in existence since 1984. It's a very valued program, and it is currently housed at the Higher Education Center at Otay Mesa. The Southwestern College Police Academy is a non-affiliated police academy, which means that it is not tied to any one particular law enforcement agency, and so anyone is welcome to apply. The way the police academy is structured is that it is an extended program. It is a 10.5-month program, and it is offered in an evening and weekend program structure. Students attend classes Tuesday, Wednesday, and Thursday evenings, and all day Saturdays. Every year we offer 2 academies, one that starts in January, another one that starts in July. Each one of those academies can accommodate up to 35 students. So every year we are training up to 70 students. As part of these academies, we also accept students from the Grossmont College Police Academy because their academy only offers part of what is required for certification. So they take the first part of the police academy at Grossmont and then transfer into our program. The Police Academy graduates who become certified through our program meet basic requirements for employment in municipal, county, and state law enforcement agencies, as our Police Academy is certified by the California Commission on Peace Officers Standards and Training, also known as POST. In addition to these 2 police academies that we run every year, the Police Academy also offers a post-certified requalification course for people in law enforcement who have had a break in their service and want to return to their field, and also an arrest and firearms course. All of these courses, the 2 police academies and the 2 additional courses, require that students have access to firing ranges. And there are a minimum number of hours that these students have to train at a range that include both daytime and evening hours. In the fall of 2008, the Police Academy director informed the dean of the need to look for an alternative range, as the one that was being used, the Miramar Sheriff's Range, would no longer be available for consistent scheduling on Saturdays. And again, that's our daytime, that's our day. The other 3 days are evenings. And again, we're required to train shooting both daytime and evening hours. In addition to the inconsistency of the scheduling, for example, we were told that we could no longer schedule the range in advance, so we couldn't plan out our training dates. We were also starting to receive calls from the range canceling our scheduled sessions. But again, in addition to that, we were also informed that the range would close sometime in the summer of 2009 for renovation and lead removal. And they were all unable to tell us whether after that renovation the range was going to be available to Southwestern College beyond that time. So research was conducted, and Dr. Chopra just went through our findings, and it was determined that using the U.S. Training Center Southwest, owned by Z Services, was the best option, as it allowed us to meet the training needs of our students in the Police Academy. And those needs are, first of all, that their availability meets our scheduling needs. Secondly, the quality of the facility is superior, and the proximity to the Higher Education Center at Otay Mesa, where the Police Academy is housed, is less than a mile away. And lastly, the use of this facility would come at no cost to the district or to the students.
Yes, are you here? Okay, thank you.
Yeah, I would like to speak against the motion. And primarily, I mean, I understand, and I have no question at all about the beauty of the facilities and the accessibility and the fact that no cost. And I also want to reiterate what one of the comments made is that there is no such thing as free. There's no such thing as no cost. I mean, we're giving all good name for somebody. And I know some of the speakers were very dramatic, but I actually have followed this corporation for the last few years. I remember reading about the atrocities that were done in Iraq, and the fact that the U.S. canceled their contract. So it's not, I mean, it's not a lot of grandstanding, but I personally have followed this. And so I tend to agree with the comments made about the fact that we cannot give up our good name for the sake of something that is, quote, free, or something that is very accessible. I would urge the board, I would urge my colleagues to please vote against this, and I'm sure that we can be creative in finding a place that is accessible, that meets the needs of our students, and with Congressman Bob Filner feeling as strong as he is, I'm sure he will help us find a facility that will meet the needs of our students. The fact that, I saw it in the paper that there's 4 lawsuits, and the national media is going to be here. It's not going to go away. We're going to be caught in the middle of this muddy, ugly scenario. And I don't think it's something that we want our students to be part of. I mean, we have to be ethical, and we have to make the position, we have to take the stand against, what's good for the college and what we think may be like, a no cost. So I would urge my colleagues to vote against this, and let's be creative and come up with another solution of where we can have our academy students practice.
Before getting into the merits, a clarification for some of the revisions, specifically the revision about the gag order, i.e. confidentiality clause. And I see that you've made some revisions, but item 7, which is the item that in the original agreement entitled media, is the one that caused the problem. So I wanted further explanation as to the nature of those revisions and why media was particularly targeted as opposed to anybody else for the application of item 7. Also, item 9, there was a specific request that the reimbursement clause be eliminated, and I see that in the revised revision, item 9, that the reimbursement clause is still in the agreement. So I'd like staff to address the rationale for that before getting into the merits of the motion.
Dr. Shelka? Do you want to call on staff for that, or would you?
Excuse me, Trustee Aguilar, if I can ask for clarification. Can you indicate on the agreement where that clause is stated that talks about reimbursement?
Well, let's go first in order. Item 7, which is entitled media in this revised agreement, and it was entitled media in the initial agreement. And that's a provision that originally caused one of the problems of the gag order, excluding the media and not allowing the colleagues to make any statement without the prior approval, etc. And I've noticed that you've made some revisions, but I want to hear your explanation as to why the media is specifically targeted in this one, and why, for example, couldn't have been entitled, or could be entitled, facility access, because that's in reading the content. It talks about who should be accessing the facility. And if you delete, in the second sentence, if you delete media, it says no other person, presumably, no other person or organization, presumably that would cover media, it would take care of it. So I want to know why it is that the media was specifically left in there when, in fact, if not, I recognize that the model that I gave didn't explicitly ask to not target media, but that was a very strong implication. So, but I want to hear from both you and even legal counsel as to the implications for targeting a specific group for this exclusion while not targeting others.
I'll go ahead and basically we left that in only because that was not one of the items that was listed as being required to be revised. But we did have our legal counsel look at that, and the language that currently exists in the amended contract is what was recommended by legal counsel as something that would be more appropriate for us to keep this particular clause in.
I wouldn't draw too much from just the heading of a particular paragraph or section.
Well, but it's actually in text, starting the second sentence, there's no media.
Correct. I was going to get to that point.
Okay.
So really what the provision provides is to who has access.
Right.
And you're right, Trustee Aguilar. The second sentence talks about that no media or other persons or organizations under the district's control will be permitted to enter the facility without written consent by the agency.
Yeah, the rest of the sentence, I think you've done an excellent job of making it clear that the college is not going to have to get prior permission to talk about the training that goes on there for our students, or talk about the police academy. But part of the problem of the original MOU was the quote gag order and exclusion of the media specifically. And unless there's, what is the rationale for specifically including media as an identifiable group? Why can't you just delete media and just say other persons, organizations, et cetera, et cetera?
I think it highlights an issue. It's trying to add clarity to what the access rights are of persons, organizations, including the media. I don't think there's anything in the paragraph that suggests a gag order or any restriction. In fact, there are recognitions as to what is required by law. That's going to be respected. And there also is protection about disclosure of proprietary information. But it really goes no farther than that.
So would there be any problem in deleting the reference to the media, both with the title and the content?
If that was the desire of the board, it's a possibility. I from a legal standpoint, I don't see that it adds or detracts much from the substance of that provision.
Okay. Now going on to item number 9. In the original agreement, that's where the clause of reimbursement resided. And in this revised agreement, I could have missed it, but I didn't see any revisions to number 9, paragraph 9. And I see specifically that reimbursement, the reference to reimbursement is still the same. And that was one of the specific items that was directed to be deleted from as part of the revision.
I apologize, Trustee Aguilar. Where exactly is that on the new agreement?
It's on page 4 at the bottom, number 9, non-obligation document. It's also the same title in the old agreement, non-obligation document. It's the second line, actually the third line if you take the title. It's about the middle of the first sentence. Since this agreement is neither fiscal nor, second sentence. Any endeavor or transfer of anything of value involving reimbursement or contribution of funds, et cetera, et cetera. And that was in the revised agreement. In the original agreement, that second sentence says, any endeavor or transfer of anything of value involving reimbursement or contribution of funds, et cetera, et cetera. So there was absolutely no revision made of this clause when there was a specific direction from the board for the motion to delete it.
In the original agreement that was submitted to the board in January, there was section D that talked about we talked about reimburse agency for the use of personnel required to operate the range, as well as provide agency the use of.
I'm sorry, what picture are you looking at?
This is at the original agreement.
Yeah, what page?
Page 2, section D.
Section D, okay.
That was the direction that the staff was provided was to delete that section that made reference to the use of conference rooms as well as to reimburse the agency for personnel. That is no longer part of the amended agreement. That's the clause that was deleted.
Okay, well, but I don't think, I see. So there, as opposed to just deleting references to reimbursement.
Well,
no, if you could explain then the implications or the significance of
I think what's helpful in maintaining paragraph 9
yes.
is that it clearly states that there is to be no reimbursement. This agreement does not deal with exchange of money for service, vice versa. And in that paragraph 9, it says there's no such authority for that in this agreement. If that is going to be necessary, exchange of money, then that
agreement.
That's right. We need to enter into either an amendment or an additional agreement that would explain and provide for that.
Okay, well, that was very helpful because to point that out and to make it clear that this reference to reimbursement in item 9 in no way obligates or imposes or creates an obligation by the college to provide Z any reimbursement of any type unless there is a prior agreement from the board. Is that correct?
That's correct.
Okay. Thank you.
Madam President,
Yes, Dr. Dominguez.
are we in discussion now?
Yes, we
Okay.
are.
A couple of comments here. You know, this is not an easy decision. It is obviously it's charged with a lot of controversy, and there are two sides to this coin. One of them is our duty to provide the best services to our students. Because we understand it's a controversial organization we're dealing with, we asked staff to go and take a look to see if we could find an alternative, because our minds are not shut to other options. Unfortunately, what we found so far is that it appears that there are no other alternatives. With all due respect to Trustee Via the Lid, I think it's a little short-sighted to just say that maybe Bob Fillner or somebody's going to find a solution for us. That may or may not happen. So, it's a difficult thing to do. What I would like to do at this point, see if I can do this, Mr. Parliamentarian, is to make a motion to table this item. We're in the middle of a motion already, so that we can look into it further, because I am not opposed if we can find an alternative solution to this, to using that solution. But at this point, it doesn't appear it's all like maybe or perhaps. I'd like to be sure that there is or isn't another solution, and if there is, then the board can consider that one as well.
Okay. For clarification,
I made a motion, I'm waiting for the...
you want a substitute motion?
He asked for clarification from the parliamentarian.
Dennis Spillane, parliamentarian. The motion to table would not be appropriate at this time. If you would like to have further consideration of the motion to amend the memorandum of understanding, you can make a motion to refer the motion back to staff, which in fact takes the document that you have before you now, the original and the amendment, back to staff, and then we continue to work on the document.
I'd like to make a motion to refer this item back to staff.
Second.
For parliamentarian, is there, what I would like to do is submit a substitute motion. And I don't want to further confuse, I want to make sure that I'm proceeding in a parliamentary manner.
Mr. Parliamentarian?
It is appropriate to submit a substitute motion for the motion to refer.
I would like to then propose a substitute motion and a motion to refer. And my substitute motion is, that's what I was trying to get clarification, so whether you were asking for a substitute motion or a new motion.
I want a motion to refer this back to staff, so I wanted to.
And what
And I thought it was seconded, I'm sure.
yes.
And there was discussion.
Okay.
Well, but I am asking from the parliamentarian to whether it would be appropriate to put on the table a substitute motion on the motion to refer. Or whether the motion to refer is indeed a substitute motion on the original motion.
Madam President, before if I can just come in and I've been given the floor.
I'm sorry, point of order, we have a question to the parliamentarian before we get into anything else.
Right, but
Mrs. Salcedo has something to add to that.
and the board chair has given me the floor. And the reason that I'm interjecting is that we can go ahead and make motion upon motion upon motion, and we can keep on going. And it's getting really super confusing. Now, my issue here is that What we are making motion upon motion about is about an amendment. What we are not, and I want to make sure that, because I need to be clear in my mind, that we're not even touching the initial contract. So if the amendment goes back and we go ahead and make all these motions, we're making...
She's talking about the merits of it, and I still need clarification as to whether the motion is
She
appropriate.
still has the.
What I'm asking of my colleagues, is that to take that into consideration, that whatever motion is being made on the amendment. It's not being made, and for us not to think that it's being made to the heart of the contract. So when we come back, we're still going to be dealing with the amendment and never touching the heart of the contract. I just want to go ahead and put that out, because we can make amendments to our amendments until the cows come home, and we're still dealing with the amendment.
Now, Madam President, we need clarification from the parliamentarian on the appropriateness
All
of
right,
the motion.
do we have a clarification then?
In displaying parliamentarian, my understanding, the actions that have occurred is you have a main motion on the floor. That main motion is to approve the amended memorandum. There has been a motion placed on the floor to refer that motion back to staff. The question of my understanding from Trustee Aguilera is, can he now substitute another motion for the motion to refer?
Correct.
And he may substitute a motion for the motion to refer.
Thank you. I propose a substitute motion. The substitute motion is to approve the revised MOU.
Excuse me. The substitute motion that you're making must be relative to the motion to refer. If you're substituting for a motion, you cannot change the germane to it.
Well, that's why I'm referring, getting there. Well, I see your point. I'll withdraw my substitute motion and see what happens. And we can discuss. But under discussion, then, when it's appropriate for me, I don't want to dominate on Mr. Dominguez's motion. So I'll wait for my comments on that.
Okay, so we need to have a discussion on refer back to, for Dr. Dominguez's suggestion that we refer back to the staff. So this is under discussion. Yes, Dr. Dominguez.
Yes, Madam President. I believe staff's done a good job of following the instructions and direction of the board with this amendment. I think it's perfect. However, my motion to refer back to staff really is an attempt for other people to try to find another alternative. Is really why I'm doing this. But of course, you gotta understand, at some point we gotta make a decision. So we're gonna. My intent is to, Bob. There's mentioned that maybe Bob Filner could help us out. We're gonna allow some folks to offer a suitable option for our students. If that can't be found, then we're gonna have to proceed with the amendment to the contract.
Any other discussion? Trustee Nutt?
Thank you. What I want to go back to once again is that the motion is being for referring the amendment back to staff. Then what comes back to us is going to be the amendment. If at the time that we go ahead and we vote, and let's assume that we go ahead and this board votes against the amendment, the contract, of my understanding, and I would defer to counsel, my understanding is that the only thing that would fail will be the amendment. We still have the contract that is still legitimate with the Blackwater. So in essence, and I'm not trying to offend anybody, but I just want to make clear with my mind that that is what we're doing. We have the amendment here that we are going to be voting. This is the contract. And when we come back, what we are asking is for staff to look at the amendment again and for us to vote on the amendment. So when in fact, if it does go and we say yes, let's move forward with it, it becomes part of the contract. If the amendment fails, the contract, we are still obligated under the contract. That has not gone away. So that is my issue. And what it is that the fact that the amendment will go away does not mean that we have terminated the contract with Blackwater. I just want to make that very, very clear. Also, I want to go ahead and just say thank you, everyone, to coming. And I would also like to thank our congressman, my congressman, who represents me as well, because I'm a voter, longtime resident of this area. And I would like to say thank you for his comments and those of his staff. My only disappointment with that is that I wish that he would have come with a federal stimulus package check or specific commitments on how his office will secure federal funding for our community college during this very critical financial times. So that is what I wanted to go ahead and say to him. But it just concerns me, going back to the motion, it concerns me that we're not really sure as to whether we're dealing with the amendment, we're dealing with the contract. There's two different issues here, folks, so we need to address them in order for this district to move forward and deal with some of the serious issues that we have.
Yeah, my understanding though is that what we are doing is referring back to staff so that if we can find an alternative facility, that then the staff can come back and say we have an alternative and we can turn down the contract if that's our wish.
For the general counsel, please.
Well, right, the clarification, and I don't know if it was a question that Trustee Bible was asking or making a statement, but the clarification that I'm seeking is, and goes to Trustee Salcido's point, that with the motion that is currently in floor to refer back to staff, the agreement that will remain in effect is the original agreement. That's the one that was approved by the board back in March, I believe. The one, and that's what would be in effect without any of the revisions that were presented tonight. Is that correct?
That is correct.
Okay. I do want to make comments, but I want to let everybody else speak before I take my.
Well, I would like to say that I am not in favor of referring it back to staff because I think that we have a responsibility to, as a board, to get on with our business again. And this is taking up a tremendous amount of time from other business that the board has to take care of immediately. We have many things on this agenda and other agendas that is imperative that we begin to look at other issues as well. This has taken up a tremendous amount of my time, my effort, my thoughts, and I'm sorry about Blackwater. I'm sorry about the things that happen with Blackwater, but that does not have to, as far as I'm concerned, does not have anything to do with the course that we are offering at this school. And I'm determined to see that we offer the very best that we can. And Blackwater's facility is the very best in the nation that we have seen. And so I think that our police academy should have the very best that we could possibly have for our program. So I'm concerned about it. I would like to move ahead with this. If we refrain from voting on this, it's just going to continue on and on and on. And like Mr. Lush said, he's going to keep coming back and coming back and coming back. And so he does, but at least we have to make a decision. And we have to stand tall on whatever decision we make. And so if we have an amendment that we are to vote on, and I would like us to vote on this amendment and these 6 items that we have, and let's move on one way or the other. Yes, Mr.
Trustee, do you just want us?
I want to bring trustee Ramirez's motion to refer back to staff to see if we have any other
Yes, the referral back to staff really gets us back to where we were the last time and doesn't make any progress. And it eliminates all of the revisions that were made that brought the agreement to a workable point. I am impressed that Congressman Filner, and for that matter, Councilman Van Wessel, who represents San Diego City Council, representing South San Diego, which is in our district, that they are willing to step up to the plate. And I would, my thinking is that we should add a condition to whatever we do. First, I agree that we should not postpone or refer the agreement, so speaking against the motion. But in doing that, I do want to say that I would like to add to the board action, not just a wish, but as a part of the original motion, that we terminate the agreement as soon as Congressman Filner is able to give us the resources, and further that we establish a task force that would include the Congressman, Councilman Wessel, Southwestern College officials, the appropriate officials, and the San Diego Imperial County's Community College Trustees Association to look into the possibilities of establishing a regional fire range that would be devoted exclusively to meeting the needs of the police academies. Southwestern College, and I believe Rosemont also has a police academy, because of Miramar, San Diego City College, so that we do proceed with this on a regional basis as was proposed by a couple of the speakers. But on the motion on the table, I would speak against the referral for the moment. Call the question. So, parliamentarian, can I call the question?
You have to have approval of four.
Well, no, what's the process, parliamentarian?
The appropriate way to call the question is to do as you did call the question when you've been recognized by the chair. The chair now must take a vote of the members of the board to determine whether the question has been called.
Thank you.
Proceed. I call for the question.
Well, I just did.
Oh, we need a second, I'm sorry.
Do we need a second? I didn't.
We need a second. Do we have a second?
Apparently not.
Okay, then it fails for a second, right?
Doesn't have a second.
So
Doesn't need a second.
So we just continue to discuss, right?
Yes.
All right, who would like to discuss?
I would also would vote against referring it back to staff. I think that staff has already done the research and has done extensive research. And my issue keeps coming back that if we go ahead and refer it back, we're not really dealing with the entire issue here. And we need to really go ahead and consider, and I do agree with Trustee Aguilar, that we need to go ahead and take a look at this. So if we're going to go ahead and take another look and see what alternatives we have, let's do it the right way. You know, we don't want to go ahead and keep on bringing the folks here in one way or another. You know, although we have differences of philosophical views, I also don't want to go ahead and keep on rehashing this over and over and over again, which is going to happen. Let's go ahead and go to the heart of it and deal with it so we can go ahead and move on instead of prolonging it even longer. Thank you.
Yes, Mr. Edwards.
I would second Trustee Salcido, she asked to call the question so we can actually move forward.
Call for the question.
Second.
Please vote. We're voting.
We're calling the question.
We're calling a voting question.
Stopping.
Yes, stopping debate.
Yes, not debate.
Are we calling?
I just wanted the board to be clear what
We're voting.
what you're voting on and what a yes vote means and what a no.
Yes.
Calling a question. Please vote. All voting yes, except for Mr. Dominguez, Dr. Dominguez. Okay? So we're going back to the motion as well. Okay?
This is a motion to refer.
This is a motion to.
Right, that's
To
correct.
refer,
Yes.
right. So now we have to vote on the motion to refer. Okay? Please vote. Failed. So we're not going to refer back to.
I'd like to substitute, make a substitute motion, Madam Chair.
It goes back to, and just point of clarification, we go back to.
I'm sorry, we have a
the
point of order. We have a parliamentarian here for
Parliamentarian
the purpose of
goes
giving
back
us an
to what?
opinion. Trustee Salcido?
Okay?
I understand that. My question is that now we go back to the original motion.
Well, that's what the parliamentarian here is.
That's what I'm asking him. I'm asking him for a point of clarification.
Trustee Salcido was correct. The motion on the floor currently is to approve the amendments for the memorandum of understanding.
And I am proposing a substitute motion to that motion. And as I understand it, that's an appropriate action at this point, given the previous motion.
Mr. Parliamentarian, is that appropriate?
Make a substitute vote.
Yes.
The substitute motion is to approve the revised agreement as presented tonight, and also to direct the President Chopin to establish a task force to develop a regional, to look into the possibilities of developing, constructing a regional firing range for the use of all community colleges that have a police academy or like requirements in the curriculum for qualifying firearms, and that we continue with the revised agreement pending the completion of such a firing range.
Madam President,
Yes.
the motion that was agendized and that the public had notice of was rather limited. The reason why we're supposed to give advance notice on the agenda is so that the public has notice, has a right to participate, has the right that many of these individuals have expressed today and shown up to express themselves. With all due respect, without commenting at all, Trustee Aguilar, on the merits of the motion you're making, it does seem to be, from a Brown Act perspective, not a parliamentarian perspective, from a Brown Act perspective, it seems to be, it is beyond the scope of the motion, the action item that was published in the agenda. I don't know if there's a parliamentary counterpart to that, but that's the Brown Act perspective.
Mr. Parliamentarian, is that correct? Is there any?
In accordance with the Brown Act, that is correct.
So
I'm
therefore-
sorry, because I just went through a workshop on the Brown Act, and I think I have. Not taking issue, but is there, what about the motion that makes it, takes it beyond the notification? Because as I understand it, the Brown Act only requires a general description of the action that's being proposed.
Essentially, you're asking for the creation of a task force, a committee that would be subject to the Brown Act, which is an action item that with all due respect, sir, I believe under the Brown Act, the public is entitled to advance notice of it. It's not necessarily a tweak or an amendment to the action items that's on the agenda. in my view, I think it goes too far.
Okay, well, I'll have to accept it sincerely, counsel, for the board, and in that case, I withdraw my motion, but in doing that, I would ask that an agenda item be posted for the June meeting, so that this board can take up the topic of directing the president, superintendent, in establishing a task force to develop regional facility that would enable community college students or any post-secondary education
Then you can ask that during the time when we give, when the board gives our request for items to be added.
Well, since there isn't any specific item where board members can ask for board agenda items, and it relates, no, just ask for reports. It doesn't specifically state that that's when board members can ask for agenda items. So I just want to make it clear that this is something that it rises out of here, and that's what I would want to request.
Point of clarification, is that a motion that is being made? We originally were setting up, moving on another motion. Is that another motion that is being put on the floor? I'm not exactly sure where we're at right now.
I think
Well, let me restate.
clarification.
No, let me restate. I said that I would withdraw my motion.
Okay.
And therefore, and in doing that, if you would listen, please, until I finish, that in withdrawing my motion, I'm expressing my desire to have an agenda item placed on the future, in the June court agenda, so that we don't run afoul of the Brown Act as articulated by our general counsel.
And I think for clarity and just streamlining this action item, perhaps Trustee Aguilar's suggestion about the agenda item is better offered under item 22, where board members have the right to request information.
That's what I was trying to say. All right, so now, Mrs. Alfina?
No, I just need clarification. So are we back on reviewing, back to the agenda, the initial motion, or we're considering the amendment? Is that where we're at? Okay.
Action item.
So we are back in discussion now. Okay, thank you.
Back in the item.
Madam President, back in
Yes,
discussion.
Dr. Dominguez.
Back to discussion. I think Trustee Salcido's points are well taken. If we refer this back and were to reject it, we would still be stuck with the original contract. I clearly understand that. I want everybody to know, my voting public, that my intent was to perhaps gain some time where we could look at this and maybe find another solution. It doesn't appear that that was an idea that would work. So I need to say that I am going to vote for the item as it appears on the agenda, with the hope that Trustee Aguilar's attempts to perhaps create a committee and his suggestion that maybe Mr. Billner can offer us another solution, at which time we can come back and take a look at this contract. But in the meantime, we cannot overlook the fact that our students need to proceed with their classes, and we have to offer them a solution, and this seems to be at this time the most viable one. But again, I reiterate, I'm doing this in the hope that we can go back and take a look to make sure that maybe there isn't something else we could do. With this in place, still look at that, and if something comes up, then we can bring this back for further consideration.
Mrs. Biden?
Yeah, and for the public record, I will be voting against the motion, primarily because I believe that, and hopefully there will be a task force that will be formed and try to come up with an agreement or an arrangement. But I just think that this organization, this company is too controversial and it has too much of a baggage to carry, and we should not have to put up with it.
been this has been really, really difficult for me, and I've gone from one side to the other, and I'm listening to everyone. And I acknowledge my colleagues' positions. I am also of the belief that this is taking way too much time for this district, for us to continue with this. Although the facilities are close by and it is cost effective for us to go ahead and have the facility there, I'm a strong supporter of the police academy as well as our recruits, and I hear the community's concerns. However, my position is that at this point in time, for me to go ahead and vote against the amendment that's before us, it takes us back to the original contract that stands. And if we had concerns about some of the language, that is done away with. So we go back to the original contract with the same concerns that were there from the very beginning. So it's like going back. The other is that I have a responsibility to our students that they are in a program at this point in time that they need to be able to use the facilities. And there is no other option at this point in time today that we can go ahead and refer our students to. I am a strong supporter that we definitely need to get out of the contract, that we need to be able to look at other options, that we need to be able to go ahead and come together with probably our community colleges partners, but that's not going to happen tomorrow. And we have to be very realistic about this. And so at this point in time, I'm not able to go ahead and take that step, just say no, because that means that it puts this district back to where we started. And I really think that we need to go ahead and take care of this, move forward. We got a huge, huge budgetary problem that is coming. And we need to deal with it, and we need to make sure that this district moves forward, and we do it in the most responsible way. I do not support this company. I don't know, I'm aware of their history, but I don't have any vested interest in them. And nor do I am doing this because I feel that there's pressure or there's, there's a lot of things that are going on. That's not the reason why I'm voting on it. I'm voting on this because we need to get moving. And for us to do anything else is just going back to the same thing where we originally started.
It provides students the best education possible. In this instance, it actually enables the students to complete a requirement of one of the most important programs for our community, and that is the law enforcement academy that we have, police academy. And more directly, that this action actually benefits students. And that's why I asked that staff present the information about the alternatives that were available to students to use other facilities. And as a practical matter, there are no other alternatives within a reasonable distance from Southwestern College that would not incur a substantial expense to individual students, never mind the institution. So on top of the fact that the students would be very much inconvenienced in having to travel significant distances to the one existing firing range that we may be able to get access to. And the third rationale is actually, I think, more ephemeral or maybe complicated, and that's basic due process. There have been a lot of allegations made about Z and their parent corporation, which I don't take issue with. But there to date, and I've invited whoever contacted me and spoke to me about this issue to provide me any information as to any criminal indictments, charges, never mind convictions, that either Z or Blackwater had been subjected to as corporations. Today I have received no such information, and no such information, credible information has been presented here tonight. And I understand that the business plan for these organizations is not my favorite. In fact, I personally oppose the business plans. But it's not. I'm not here to make policy decisions on my personal, ideological, or political positions. I'm here to represent the best interest of first the students, and to promote the mission of this institution to provide the best education possible for our students at the most reasonable and most convenient, at the most reasonable prices and at the most convenient facilities. And this agreement, as revised, meets all these requirements, and I would therefore again support the motion to approve the revised agreement, and hope that we can move on to find a better solution. And when we do that, we can come back and terminate the current arrangement.
Okay, call for the vote, and if we're to approve the amendment of the memorandum of understanding, does everybody understand what we are approving at this point? Okay, all right, please vote. Okay, vote passes, all saying aye, but and this is by delete. Now, at this point, I think we need a 5-minute break.